The perception that lawyers are stalling corruption cases and the arguments by some lawyers that they are now targets of EFCC and the agencies persecuting them, how do you balance that?
Well, I think from the perspective of the public, I think there's need for proper education as to the role of a lawyer in the society, particularly defense counsel. The law under which we operate is called accusatorial system. Under that law, an accused person is presumed innocent. He has a right to a meaningful day in court. Indeed, he has a right not to even discuss anything with EFCC, ICPC, until he has spoken to a lawyer of his own choice. So I plead that lawyers should be seen the way doctors are seen. When somebody is sick, he goes to a doctor, and when he gets healed, he says his doctor has done well. So by the same token, when a person has a problem, he is entitled to the guiding hand of a lawyer. So a lawyer defending an accused person is merely doing his work. And I also hear that accusations here and there that lawyers charge a lot of money from those persons accused
to help them
get out of it.
Yes.
My response is that if your case is bad, it is bad, no matter the amount of money you put down. Let the prosecution do its case, let the defense do its case, let the judge decide. I hear these days that judges are also being blackmailed by the prosecuting agencies. Some of them are being intimidated. Well, I have news for those who are prosecuting, that you decide either to prosecute or to persecute. And if you want to presume that every person accused of an offense is guilty of an offense and should prove his innocence, let us change the law to the civil system, whereby the accused person is presumed guilty and he should prove his innocence. As for lawyers becoming endangered species, so to say, well, every profession has its own challenges. And I believe that if you are clean and if you practice your profession in a very clean manner, you have nothing to fear. But if you're not clean, they bug your phone, you change the phone, they bug it again, you will be caught. But let us as lawyers see it as part of our professional hazard. And that hazard, like every hazard, will still pass and become a matter of history.
I know you're defending some high-profile cases, and we've heard allegations that the EFCC is targeting some of the lawyers involved in these cases. Can you confirm for us that the EFCC is bogging funds?
Well, when I speak to people on my phone, they will tell me they're not hearing me properly. When I use another line, they hear me properly. That is a sign that something is happening. I'm not sure that it's EFCC, but somebody is placing a tap on the phone. Well, as far as I'm concerned, there's nothing I'm doing. I always tell people that is secret, that will warrant. So, a few of my friends have also confirmed that they are also under surveillance. But in a civilized environment, it should not happen. As a matter of fact, those people who are tapping the phones are invading the privacy of the lawyers and whoever. Because if you look at the Constitution, it guarantees the right to privacy. It says the privacy of citizens, their telephone communications, and other forms of communication are hereby guaranteed and protected. That right is there. So that if you get information based on tapping of the phone, as you are suing that person to court for whatever, that person also has a right to sue the agency to court for the invasion of their privacy. I'm not sure those who are tapping phones are aware that lawyers whose phones are being tapped also have fundamental rights against those people tapping their phones. But then those are the rights waiting to be activated against such agencies if and when there is evidence of such tapping of phones.
But isn't there a justification that it is being done in the interest of the public? I mean, if we're talking about public funds that have been looted and an agency is tapping to get information about such funds, wouldn't that be a justification for the agency?
What you are saying is that fundamental rights are not absolute. But then for a lawyer who has not worked in government, who is a private practitioner, by tapping his phone, you are not looking for funds looted by his clients. You are looking for information about him. If you are tapping the phone of a looter of funds, yes, you might be saying for the purpose of discovering whether that person has committed an offense. But not when you tap my phone or tap your phone and listen to all my conversation, relevant and irrelevant.
Including the ones where the clients confess to their lawyers that they committed some of these crimes.
I have news for you. Such confessions are not admissible in evidence. Communications between a counsel and his clients is absolutely privileged. Nobody can give that information unless, even not even the lawyer, unless the client waives his privilege. Like I said, it depends on who is arguing a case in court. You dare not bring such evidence of what you have had me discuss with my client on the phone to court. I will knock out the evidence. It is absolutely privileged.
What we hear is that they don't take these statements to court, but they use it to confront the lawyers and their clients so that they can admit to the offense.
It depends on who is involved. I've had cause to visit one of the agencies before, and I was telling the young man, very arrogant young man, that I'm here because you have issues with my junior. And he said, which issues do you have with your junior? You must tell me. And I said, you? Tell you what? You can't force me to tell you something. I either tell you voluntarily, I don't want to tell you voluntarily. And I say, I am not telling you. So it depends on who is handling a particular matter. If, for example, the client you're talking about is also a lawyer, or he's close to a lawyer who has advised him or her of his right, and he says, look, I'm not talking. A person who is being investigated has a right not to make any statements.
That's not an obstruction of justice.
Until he goes to court. He has a constitutional right to remain silent. That is the law. So, obstruction of justice, if you must say, will be in the criminal code. We are talking about a right in the Constitution, which is the supreme law of the land. So that criminal code is not consistent with the Constitution. So it is null and void. Like I said, it depends on who is on the driver's seat.
There is an urgent need to insulate magistrates and judges by providing them with better working conditions. The allegations that some defense lawyers have their phones tapped by some agencies of government is a breach of their fundamental rights, and it would be proper for such lawyers to activate these rights. These are some of the thoughts of my guest, Professor Taiwo Osipitan, Senior Advocate of Nigeria. What do you think? Please share your views with us using any of our social media handles. Don't forget that you can find these and past episodes of the program on our YouTube channel. I'm Shola Shieli. Thank you for watching.